going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Sunday. Happy Sunday. I hope you guys had a great weekend. It is Sunday, so yeah, work starts back tomorrow for, everyone who doesn't have the weekend. I don't know what I'm saying. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got 4 cases tonight. The first one is a case that I've been following. For those of you that have been, paying attention, we've seen the pre-trials on this, and now we actually get a hearing on it. So the first guy, he's the guy who he's charged with distributing, right? So, but he said that the cell phone's not his. They can look up. And he's like, the cell phone's not mine. It's under this person's name. I have a different cell phone. There's no way this cell phone's mine. You can't use this cell phone against me. We finally get the hearing for it. We're in Florida. This is Judge Collier. Yeah, it's interesting. The entire premise is interesting, right? So a guy who got pulled over and they found a bunch of illegal items in the dude's vehicle. And he's trying to get the entire thing thrown out because the cell phone's not his. Yeah. Okay. Let's see how that works for him. Judge Collier, Florida. Let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, come on down, Mr. Haddix.
You know what? I saw KFAR here, so sharpening pencils. I'm going to say this because KFAR is here. My crayons are sharp. My box is full. My glue's topped off. My helmet is tied tight. We're getting ready for this day. Let's go. That's for you, KFAR.
All right, I reviewed the motion to suppress. I didn't see a copy of the warrant in the clerk's file. Is this a joint exhibit?
Yeah, that's
okay.
Fine. Yeah,
perfect.
I saw the pictures on the front. I recognized it.
All right.
So that's the copy a copy of a copy that I received in discovery.
All right, so I'll take judicial notice of the affidavit for the search warrant and the search warrant in this case. All right, Mr. Hill, you want to call your first witness?
Before we get started,
Yes,
I
sir.
ask the court to. The court has heard, as has the state and anyone who's been here in court for the past several months, listening to Mr. Haddix tell this court that that's not his phone. He went so far as to give us the name of a female that the phone belongs to, that's not his phone. The state would submit that if that's the case, Mr. Haddix has no standing to challenge the search of the phone. And I have a case from the first DCA, Burgess versus State. It is 939 Southern 2nd 219. If I may approach.
Yes, sir.
This case actually relates to luggage, not to a phone, but it clearly indicates that if the defendant is denying ownership of the phone, or in this case, the luggage, then they have no standing to challenge the search of that item. And Mr. Haddix has on numerous occasions in front of this court denied that that is in fact his phone. If that's not his phone, then he has no standing to challenge the search of the item.
Mr. Hill?
Judge, upon review of the evidence that we received in discovery, there's evidence that Mr. Haddix was in fact in possession of the phone at the time the phone was collected by the agents up there in the state of Georgia. Mr. Haddix provided the agents there with the PIN number to get into the phone. So, like I said, there is evidence out there that Mr. Haddix was in possession of the phone at the time it was collected.
So it's Mr. Haddix at this time under oath want to say that the phone was in his possession? I mean, right now he's made statements that the phone's not his. I understand what law enforcement has said in their complaint affidavit. But Mr. Haddix, if he wants to proceed to challenge the search of the phone, needs to not ownership of it, but at least state that it was in his possession.
I don't think Mr. Haddix is going to deny possession of the phone, Judge. It's clearly on video. The body worn camera footage that the officers were wearing at the time they encountered Mr. Haddix up in Georgia at his place of residence. Mr. Haddix had the phone in his pocket. He handed over the phone to the officers, and when requested, provided the officers with the PIN number to access the phone. So Mr. Haddix is not denying that he was in possession of the phone at the time the officers collected it.
All right, I need some facts to that. Mr. Haddix, you raise your right hand.
All right. A little bit more backstory. Mr. Haddix tried to fire his attorney the last time I covered him. They went through, I don't know, it was about a 10-minute, it was just a review or a summary or a pre-trial. I have no idea what kind of hearing it was, but Mr. Haddix asked for a Nelson hearing. And then by the end of talking to Judge Collier, he decided to retract that, and now he's using his attorney. But this is a weird story, guys. It really is. And I gave you the summary. His whole defense is it's not his phone, but he had the phone. So we're about to hear a lot. Just get ready real quick. Rich, thank you so much for your super chat. Thank you. To alleviate the Sunday blues, jump kick backflip. Thank you so much, Rich. I appreciate it. And Legal Fiction with the 10 gifted memberships. Thank you so much, Legal Fiction. Welcome to the 10 new members. Thank you so much, Legal Fiction, and the 10 new members. Big and Raid? We got Big and Raid already? All right. I wasn't prepared for this already. You guys just jumped into it. Everyone coming over from Big And's channel, thank you so much. Big and thank you so much for the raid. I do appreciate it. We just started. There's not a lot to say except the defendant here is charged with a bunch of different things. One of them being distributing. He had illegal things in his vehicle when he got pulled over, but they did a warrant search on his phone, but he's claiming it's not his phone, and the whole case should be thrown out because they did a warrant search on a phone that wasn't his, even though he was in possession of it. It's really weird. This guy tried to fire his public defender. He was talked out of it, but this is the hearing. So that's where we're at. We're just getting into it. So everyone coming over for Big and you haven't missed anything. GG of 2. Thank you so much for becoming a new member. That is awesome. Welcome to the family. Thank you so much. Thank you. Okay, you guys ready? Biggin, you're awesome. Thank you for the raid. Let's go. All right, hold on. Peeps for 19 months. Thank you so much, Peepla. That is awesome. Thank you so much for the milestone. 19 months. Thank you. Okay, let's go.
Hey, Mr. Hill, you want to query him on that limited issue of whether or not he had the phone in his possession at the time of the search?
I will. You state your name for the record, please.
Monte 9080.
Mr. Haddix, when the agents with the probation office and Georgia Bureau of Investigations came to your residence several months ago to search the residence, did you provide them with a cell phone that was in your possession?
Yes, I did.
At that time, did you provide?
All right. I was going to wait a little bit to pause again. I'm sorry, but we got 3 milestones right back to back. Marty for 16 months. 16 months. Thank you so much, Marty. I appreciate it. You are awesome. Darth J for 2 months. Thank you so much, Darth J. And Chris, the one and only Chris for 10 months. Thank you, guys. You guys are awesome. All right. Thank you. Let's go.
The officers with the PIN number.
Madam coming in with 7 months. Thank you, madam. Thank you. Thank you to all 4 of you. You guys are awesome. Thank you so much.
number to gain access to the phone itself.
Yes, I did.
You have any questions on Mr. Patterson?
Mr. Haddix, that phone that was in your possession, is that the phone that you were using at the time?
It was.
How long had you been using that phone?
Say like about 2 months.
Based on that limited testimony, I'm going to find that Mr. Haddix does have standing to challenge the search in this case. It looks like there's a warrant. So burden's on Mr. Haddix. You want to call your first witness, Mr. Hill?
I will, Judge. Mr. Haddix, if you'll take the witness stand, please.
All right, Mr. Haddix, you're still under oath. The lawyers will have questions for you.
Judge, I'll ask some simple questions. State your name for the record, please.
Diamante Nazir Haddix.
Mr. Haddix, you are one of the listed defendants in this case involving 25, 38, 39, 40, 41, 42, 43, and 44, correct?
Correct.
Back in several months ago, you were living in Georgia, correct?
Correct.
Were you on probation in Georgia?
Yes.
Did the probation officer that was supervising you and other members of her staff and the Georgia Bureau of Investigations, did they come to your residence to do a search?
Yes.
When they searched the residence, did they ask for, did you provide them with a cell phone?
Yes.
Was that cell phone in your pocket?
Yes.
After you provided them with a cell phone, did you give them the PIN number to access the phone?
Yes.
And that is the phone that you had been using up until they took it from you, correct?
Yes.
That's all the questions I've got for Mr. Haddix, Judge.
All right, Mr. Patterson.
Wow. So his entire that's the defense attorney saying that. Yeah, this is weird. I don't know what defense they're making. I don't know why this hearing's even a thing. Was this phone in your possession? Yes. Was it yours? No. Was it yours? Did you have it on you? Yes. Okay, no further questions. Okay. All right. There's a lot of drama to this case before this hearing, so just letting you guys know.
I don't have any further questions.
All right, thank you, Mr. Haddix. You can have a seat next to counsel.
What? Why are we even in this hearing? Sorry guys. Sorry. Hopefully this doesn't turn out to be a dud. I really hope it's not a dud, but that's really weird.
Any other witnesses, Mr. Hill?
No further witnesses, Judge.
Mr. Patterson, any witnesses?
No, Judge, I think states.
Just real quick, so the defendant tried to fire his defense attorney. He tried to fire his public defender. He's claiming the cell phone wasn't his. The cell phone is what carries all of the evidence against him for distributing. He's charged with distributing. Some people like to call it a drug dealer, but I'm going to keep with the legal terms, distributing. And so he's facing a lot of years because he was on either parole or probation when this happened. Now, the defendant is claiming the entire thing was illegal because it's not his phone. They had a warrant for a phone that wasn't his. So that's been his defense the entire time. So now he finally gets his hearing and nothing's going so far. That nothing has happened. So that's the quick background. Okay, let's go.
Found by the four corners of the written document.
Okay, any argument?
Judge, I'll rehash the argument that I made in the motion for the purpose of the record. What we have is a search warrant that the Gulf County Sheriff's Office obtained for an Apple iPhone 13, black in color, passcode 320715, bearing a serial number of FPYQ57HR.
All right, we don't need to hear that. I don't know if the serial code does anything for anybody, but yeah, we're gonna mute that part.
officers were attempting to search. With their search warrant, they provided an affidavit to the reviewing judge in this case. Upon further examination of the affidavit that the officer submitted in order to obtain the search warrant in this case, there is no mention whatsoever of, number one, how law enforcement came to be in possession of this phone. There is absolutely no mention in this affidavit as to this phone belonging to the defendant, DeMonte Haddix, or any other persons. There is plenty of evidence mentioned in here about the co-defendant and the iPhone 11 that belonged to the co-defendant. But as far as the information pertaining to this phone and who it belonged to, where it come from, and why they thought evidence of a crime may be on this phone, this affidavit is void of that information. And the case law and the law is very clear in a situation like this that the reviewing court is obviously bound by the four corners of the document. And in order for law enforcement to obtain a search warrant, the affidavit has to include two basic elements, which are that there is a commission element that a crime has been committed and a person committed a crime. Number two, the nexus element, which that there is criminality likely to be found on this phone. They do allege in the affidavit that Mr. Haddix was a co-defendant in the criminal activity. However, the nexus element is completely missing. There's no evidence in this affidavit that shows or suggests that any evidence related to this crime is likely to be found on this particular phone, because, like I said, there's no connection to Mr. Haddix or any other person about the phone, or that any information is going to be found on this particular phone. So I would ask that the court consider the four corners of the affidavit, the argument in the warrant, and the facts that are laid forth, and grant the defendant's motion to suppress in this case.
Why couldn't law enforcement just use the pen to access the phone? Is Mr. Haddix gave law enforcement the pin to the phone? How do I, or should I consider that, not consider that? Is there consent to search the phone? How should I evaluate that fact? If at all. And assuming that a pin is access to the phone.
Judge, I would argue that simply giving officers the PIN number is not a valid waiver of
bullshit, counsel. Bullshit. All right. Hey, here's the phone, here's the PIN number. Oh yeah, so now if I look into your phone, that's I'm gonna get in trouble as an officer? No. You give someone your phone with the PIN number, you know they're an officer, you're not waiving anything. That's like saying, hey, I'll let you search my car. You arrested me, I'll let you search my car, but you can only search the trunk. You can't search the rest of the thing. If you look into the rest of the car, then no, that's illegal search and seizure. Yeah, you gave them the phone with the PIN. What did you think they were gonna do? Okay, defense attorney. Let's see. What's the rest of your argument?
a valid consent to search phone, because I mean, nothing was ever said to Mr. Haddix when the PIN number was requested. They simply asked him what the PIN number was, and he gave it to them. As far as asking him for consent to search the phone, explaining to him that he's got a right to refuse, none of that was ever considered, was never presented to Mr. Haddix. So I would argue that simply giving the PIN number to the officers is not consent to enter the phone, and certainly not consent to search the phone for the extent that this search warrant, because when they got the search warrant, they did a data dump, and said the data dump obviously provided a lot of information on the phone, and I'm not 100% certain, but I believe the data dump, when you do one of these data dumps with the Cellbrite, they're able to obtain information that has been deleted off the phone, off the SIM card. And that being the case, simply giving a PIN number is only going to provide somebody with access to what's on the phone currently.
Yeah, this defense attorney stretching. I'm going to go ahead and go out on a limb here and say, when you're a defense attorney and you're constantly defending people, you know how data works. SIM cards aren't really used that often anymore. Everything's stored on in the cloud, right? So yeah, some things are still stored on your SIM card, but you're transferring phone to phone. I think he's stretching here. He's leaving a lot out, maybe intentionally, but yeah, no, he gave his phone to the officer with the PIN code. There's nothing to stop that officer from going through there, especially if they think he's charged with distributing. They're going to look through his phone. Yeah, don't give him the PIN number and then argue this later. I do appreciate the attorney doing his best. The client kind of put himself in this position, and the defense attorney is just trying his best. All right, I'm going to stop pausing. We're going to finish this one up. There's still quite a bit to go, but let's go.
It's not going to provide access to things that have previously been deleted off the phone and may be on the SIM card somewhere. So again, I would argue that simply giving a PIN number to the officers is not consent. It's not consent to search the phone.
All right, Mr. Patterson.
Your Honor, state would argue that there is a nexus listed in the search warrant itself, in the document. The court looks on the second page of the search warrant, paragraph that begins the second suspect. The last sentence of that paragraph says, as he leaves the scene, the suspect can be seen with a cell phone in his right hand, which he appears to unlock and begin using. If you read further up in the search warrant, Your Honor, there was home surveillance cameras at some of these burglary sites that captured the suspects in progress. So there's a phone mentioned there at the time of the burglaries themselves.
Yeah, they do. SIM cards will store data. They can't store a lot, but they will store some. So they can store SIM cards. They can't actually do that. But most people's data is on the cloud right now, especially with iPhone users, Apple users. Everything's Apple Cloud, right? So this guy had an iPhone. Yeah, I don't really know what else to say to that. I know I just said I wasn't going to pause again, but we have a new member, so I wanted to pause it for the new member. Shedleski. I wanted to call you Shady, but I don't want to. But I feel like reading your name, I want to call you Shady, just because of the letters. But Shedleski, thank you so much for becoming a new member. Welcome to the family. I do appreciate it. All right.
The next paragraph continues that they located the co-defendant, Mr. Moore. They spoke with him. He implicated Mr. Haddix in the case. And they searched Mr. Moore's phone. They got Mr. Moore's phone, and in the search of Mr. Moore's phone, they located a contact named Monte. It was identified as DeMonte Haddix.
Yeah. I keep pausing. Rodin, I'm the exact same way. I barely use the cloud. I do everything locally. I have external storage for everything. I like the cloud. It's very convenient, but I use the cloud for very specific things. I don't use it for personal information because I still, to this day, do not trust the cloud, and it's going to be a while till I do. So yeah. But yeah, you guys are awesome. Let's go.
And they continue to say that there's believed to be evidence associated with the burglaries as well as possible location of stolen firearms contained in Haddix's phone. In addition, a second interview was done with Moore, where Moore admitted to law enforcement officers on page 3 of the document that he had retained possession, that Haddix had retained possession of one of the stolen firearms, and the two of them, meaning Moore and Haddix, were in contact before and after the crimes via their cell phones. So there is a nexus that there was potentially evidence in that phone sufficient enough that a judge could issue the warrant. And that is in fact what happened in this case. And once the warrant is issued, there's been no evidence or no allegation that law enforcement somehow lied or misled the judge in obtaining this warrant. They simply laid out the facts of the case, and they do list in there a number of items of potential evidence, including location data. That's part of the warrant that they wanted to get, was the location data of the phone. And they listed that those phones were seen on camera during the burglary. The two co-defendants were communicating through that phone, and that there was a contact in the co-defendant's phone identified as that. So that was all sufficient enough for the magistrate, for the judge or the magistrate in this case, to issue the warrant.
Mr. Hill, anything else?
Judge, I would simply point out that that second paragraph that the state referred to, the sentence about as he leaves the scene, this suspect can be seen with a cell phone in his right hand. That paragraph is referring to the co-defendant Thomas Edward Moore. And the fifth paragraph, where the last sentence states, as a result, is believed the evidence associated with burglaries, as well as the possible locations of stolen firearms, is contained in D. Haddock's phone. There's nothing else in this affidavit that would tell the court that's reviewing this case that this iPhone 13 that they have that they're wanting to search belongs to Mr. Haddock's. I mean, they had that information, but they neglected to put that information in the affidavit. So therefore, we're not able to consider it at this point. But that's the idea that we can just randomly pick up a phone and get a search warrant and say that it belongs to must belong to Mr. Haddock. I mean, that's what, in essence, they're asking us to do, is just assume that this phone belongs to Mr. Haddock without putting it in the affidavit. And like I said, I'm asking the court to grant the motion because the state, the law enforcement, they left out key information that the court needed to make a probable cause determination in review of this warrant.
Hey, Mr. Hill.
Yeah, here's the problem. The defendant already said he was in possession of the phone. You put him on the stand, and he admitted to being in possession of the phone. Yeah, I don't know what else to say. I really don't. There was one. Dave Mid for 14 months. Thank you so much, Dave Mid. I appreciate it. Good to see you, my friend. Thank you so much.
Brings up that the officers did not lie or mislead the issuing magistrate. Guess referring to the good faith exception, you want to address why it doesn't apply, Mr. Hill? Or why it wouldn't apply? And I'm only asking because I don't want to address when Mr. Patterson used that language. I believe you're talking about the good faith exception. I don't want to talk about it in the order without giving you an opportunity to address it.
Absolutely, and I'm by no means am I suggesting that law enforcement did anything to lie or mislead the court. They just simply neglected to put in their information that they had on hand, and like I said, that information that they based on what we know in other reports, not in this affidavit, they had that information available to them, but for whatever reason neglected to put it in the affidavit. So therefore, we're not able to consider that information that they had on hand because it's not in the affidavit. And like I said, the information that they omitted, failed to include is critical information for the court, the reviewing court, to determine whether probable cause. And like I said, without that information, we have no evidence in this affidavit that the phone belonged to Mr. Haddock's, that it was collected from Mr. Haddock's, or in fact, it belonged to who it belonged to. They don't tell us anything about who the phone belonged to. And so for that reason, I believe that the court should grant the motion.
That is the best defense that they have, and it's a good defense, but it's I mean, he's reaching at straws right now without any evidence of who the phone belongs to. We don't know who it belongs to, therefore you can't say it belongs. Yeah, I mean, I get it. That's what you're going with, but yeah.
Your Honor, if I may.
Yes, sir.
Just to be clear, the state was not intending to mislead the court either. That suspect was in fact Mr. Moore that had the phone on the scene of the burglary in the video. but simply pointing out that there were phones present
Yes, sir.
during the time of the commission of the crime. And as far as identifying it as DeMonte Haddox's, there's a paragraph that talks about the contact from Mr. Moore's phone listed as Monte communicating with Mr. Moore, and they believe that to be associated with the phone number belonging to DeMonte Haddox. That is listed in the warrant.
All right, thank you. I'll take this under, unless there's anything else, I'll take it under advisement. I'll issue all a written order.
Thank you, Judge. We've already got a pre-trial date set. We've got depositions already scheduled, Judge. and we'll
Perfect.
keep the court up to date on where we're at with the progress.
Thank you.
Thank you, Judge.
We don't have a pretrial date. Well, let's just come back on
9/9.
9/9. And I'll definitely have an order out before then. You ready, Ms. Miller?
If I could have 1 moment.
All right, Mr. Sean White. I'm going to tell you this, and we haven't gone back and forth in the comments because you refuse to answer my comments back, my responses back to you. But here's what I'm going to tell you, man. Go somewhere else. That's all I'm going to say. I don't care. I don't. You want to come at me? That's fine. You don't like me? That's fine. Guess what you can do? You can leave. I don't care. That's what I'm going to say. All right, we're going to move on to the next case. And we're all caught up on super chats. You know what? While I'm paused. So I got a question for everybody. Talk more. Yeah, I can absolutely talk more. No, the best part about that guy is he leaves comments, and he's commented on over 40 of my videos. And I like his comments generally because they're constructive. For the most part, they're constructive. Here he is. Yeah, I know you don't dislike me. Like your comments are not destructive. They're constructive, like for the most part. But it just at some point you just gotta be like, I'm not changing. So I know you want me to talk less, and I do listen to every single one of your comments. I do. Everybody that leaves a comment that that they don't like how I run my channel, that's fine. But I read them all. I read every single comment. Doesn't matter for what I'm about to say. So what was I gonna say? Tuesday. So Mr. Magoo is back in front of Judge Simpson on Tuesday. Do you guys want me to go to that? I'm asking. I'm generally asking. Do you want me to go to that? Does it enhance your court experience when I'm there? I honestly want to know. Because I want to go, but I lose a lot. I lose a lot when I travel to Michigan for court. I miss an entire day of court. So I'm just asking, do you want me to go to that? Is that something you would like to see me at? I'm just asking. Anybody, whoever wants to give me their opinion. Do you want to see me Tuesday in Mr. Magoo's preliminary exam, or would you rather me comment on the sidelines like I usually do? Jedi, thank you so much for the generous super chat. Pause more. Yeah, I appreciate it, Jedi. No, I already forgot his name. No, the guy that was commenting, he comments on my videos all the time, and I listen to him because he usually like he doesn't send hate. He just it's how he feels. But yeah. Anyways, you want me to go or not? Am I going to Magoo on Tuesday or not? Wolf Lore, thank you so much for the Magoo trip fund. Thank you so much. I appreciate it. All right, if you guys are going to continue to donate, then I'm going to have to go. I'm asking a question if you guys want me to go or not, but if you're going to continue that, I'm going to have to. Wolf Lore, thank you so much for the generous super chat. Thank you. All right, let's go on to the next one. Let's just move on. Speaking of Judge Simpson, we're going to go on to the best Judge Simpson case of the week. I have not played it yet. This one's good. Let's go.
Court does call the cases of the people versus Samuel Peoples.
Thank you, Richard. People.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 132.
Magoo is scheduled for 12. I want to say he's the 12 o'clock block. I don't think I've looked it up in a couple of days, but it's in the afternoon, so I don't have to leave at 3 a.m. I don't have to wake up at 3 a.m. to make it there on time. But he's in the afternoon. That's yeah. I believe that's correct. But it's on Tuesday. It is on Tuesday.
6. Mr. Peoples has not yet been referred to the forensic center. I've prepared an order, and we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my next date? Let's see now. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just next week.
That was last week.
Yeah, so let's go ahead and advertise other people's channels. Okay, so Wixom is going to be on KFAR and KDZ to let them know what happens. So I guess that means I need to go so I can tell you guys what happened. I guess I don't know. Wixom, I don't know what the point of this message is. I really don't.
All right, so set a conference here, October 2025, 9 a.m. All right, what are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326. Which is charged as a felon, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's listed.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I thought so.
Response?
Your Honor, obviously we had an extended conversation about this at bench at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're gonna cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before, you just did it?
I had a moment of anxiety that led to a freak out. Yes. And I felt like I needed to get it off me because it was claustrophobic and
Got it.
yes.
I hear you. Okay. All right. He's gonna be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your
Um, council approach. It's the strap. And I just need a bond, the blue form, reinstating his previous bond with condition. All right, good.
Yes.
Okay. All right. Samuel,
Yes, Your Honor.
I give you another shot. You gonna try to do the right thing?
Yes.
Okay.
Thank you, Your Honor.
All right. I'm gonna do it. I think you can do it.
Me too.
Okay.
All right.
Yeah.
Thank you.
So what's gonna have to happen is somebody's got to pay money for the strap that got damaged on your tether.
Understand.
I'm gonna reinstate your previous bond where you were previously at home, right?
Mhm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay? Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After
Sure.
consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor, without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response.
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened.
I took those out. I took those out on purpose. I don't want people to feel like they have to donate. Sparkle Poots, thank you so much. My link tree is in somewhere. I'm pretty sure one of the mods can post it, but yeah, I took that out on purpose. I don't want people to feel like they have to donate. So, but Sparkle Boots, thank you so much. But now that you brought it up, if any of the mods want to drop my donation links, my link tree, thank you. Thank you, Sparkle Boots. All right, this is about to go south real quick. One of the few times that I Miss McDuffie just should stop talking. I know she's very passionate. She's very good at what she does. She backtalks the wrong judge though. Even someone like these two have a great relationship. They do. I want to say that McDuffie and Judge Simpson have a great relationship, but this is a little too far. Yeah, let's go.
And where they are, and if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office, so that the court would be apprised of what was happening. But the tether conditions, I believe, want to remain the same.
Actually, what happened last time was the public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for.
Yeah. We're going too far right now, but Wixom, I do appreciate it. I'm not asking you to cover my expenses, but I do appreciate it. I want to go. The biggest problem is, you know what? I'll explain everything after this clip. I will tell you why I'm hesitant to go, But let's finish this clip first, Wixom, and you guys will all understand. I said it in Discord the other night, Wixom. I know you were there, you heard it, but I will say it again. So let's finish this clip though.
Was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here, because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking. You huff one more time and we're gonna have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
Bull, I will tell you exactly why I'm treating him like he's normal. Because Judge Simpson trusts him. That's all it takes for me. If Judge Simpson trusts you, that's all it takes for me. I don't need anything else. Yeah. I heard the entire story and I have my thoughts, right? But I'm one of those weird people that, you know, I trust Judge Simpson's instincts. He's right more than he's not. So that's why I am for him in this situation that I am McDuffie. And I love McDuffie. I do. I tried so hard to get her on my channel. She's the reason why I don't interview people anymore, is because I spent so much time chasing after her to get her on my channel, only to be ghosted. So I stopped. But yeah. If Judge Simpson wants to let this guy out of jail, I'm gonna go with it. That's just my thoughts. All right, let's finish this one up.
Your Honor, I'm very familiar with Mr. Peoples' case if the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make.
No, she didn't ghost me. Well, kinda. I called her. I got to know whoever answers the phone for the prosecution. I got to know her really well. I talked to her, I don't know, 2 or 3 times a week for about 3 weeks, trying to just chase down Miss McDuffie, and we had great conversations, and she just never called me back. So I just gave up. So that's my story. I did really try to get Miss McDuffie on the channel, and I'm not mad at her for not wanting to come on. Like, I totally get it, but yeah, that's where I am. That's where I'm at with it. It's like I tried. She had my name in her inbox probably, I don't know, 20 times over a month period, and she never returned an email or a call. So, and I say that because Judge Middleton called me back. A lot of people call me back or email me back. When I was searching for interviews, most people would respond. Most of them would, and they would just say, you know, I I'm not going to do it. I respectfully say no. McDuffie just never did. Yeah, which again, but she never led me on, so I don't have any ill will towards her. Not like Judge DeSanto, who led me on and then, completely just took my narrative and made it her own thing. So, yeah, I have no ill will towards McDuffie.
His bond in his new case matched the bond with the conditions in his other case, so that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid. And all prior conditions are reinstated. And then we need a new date, so when do we?
Your Honor, my request.
Well, I got the competent, it's actually gonna be October 30th.
Okay.
It's gonna be our day, so, all right.
Thank you, Your Honor. May I provide the court with the order to undergo forensic?
There hasn't been enough on this case yet, Mr.
I'm
No,
not.
go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's the order on the other case. I'm sorry. Not a problem.
Might be tomorrow, but as soon as they put the feather on you.
You'll take it.
Okay. Sounds good.
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're gonna do it, right?
Yes, Your Honor.
All right. Okay. Thank you.
All right, I got a little carried away there, guys. I'm sorry. Let's just move on. We're gonna move on to Judge Hesselink. I do have a few super chats real quick. I believe I said I don't know where I left off at. I really don't know. I know I said thank you to that. Okay, we're gonna jump down here. Rich Magoo Fund. Thank you so much, Rich. I do appreciate it. Thank you so much. And Chris with the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, Chris. Alex, thank you. Magoo feed just to see you on screen. All right. Looks like I might have to go. Which is fine. Thank you so much, Alex. And Sparkle Boots with the 1 gifted membership. Thank you so much for the gifted membership. Welcome to the new member. And James, thank you so much for coming a new member. Welcome to the family, James. Membership Monday is tomorrow night. I hope to see you there. And Phil, I do need a Snickers. I need a Snickers so bad. I need a Snickers. I think I am hangry right now. I need to cut it out. I'm hangry. We're just here to watch court, and I need a Snickers. All right, you guys ready? We're jumping to Judge Hesselink. What's the girl's name? The one that everyone's been following, who you know what? Let's just go. You might recognize her, you might not. Let's go. Hold on. Wixom. If you come, Bob and yeah. Yeah. Okay. The problem with me, see, here's the thing, Wixom, and Bob found this out the hard way. You guys all found this out. When I travel, I don't eat. Because when I eat, I fall asleep. You guys have to understand. I have come to understand my body. Every time I eat, I get tired. And I don't know why. But every time I eat, I get tired. So when I travel, I don't eat. So I will be more than happy to go hang out with you guys for lunch, but I'm not going to eat anything. But I'll go hang out with you guys. I fall asleep, especially when you wake up at 3 a.m. to make the trip. It changes things. So yeah, I can't eat because I get tired. Yeah, that's all I got for that, Wisdom. But I appreciate it. I do want to come up. And I will probably be there. Oh, I explained to you. I told you guys I would. All right, so we're actually going into the last case, so I might as well say this. You guys know that Heather and I broke up. We're still friends. We're still working on our relationship. She invited me up to Canada, and I'm going up there. I'm going up there on Friday. So that's why I'm kind of hesitant to go on Thursday or on Tuesday, because yeah, it's money I don't have, right? So going up there on Tuesday would be great. I want to go see Magoo in person. I want to reach out to Miss Wilding, who emailed me and said next time you come up, make sure you let us know. But here's the thing, I'm about to drive. What is it? 1,500 miles to Nova Scotia on Friday. So the Tuesday thing is very minimal to me. I want to go, but I gotta save my money, guys. I really do, and that's where I'm at. Um, that's hard for me to say. Yeah, I shouldn't have said this. Like that's very personal information. Jedi is about to yell at me because Jedi tells me to keep everything personal, and I don't. Heather tells me to keep everything personal, and I don't. I'm an overshare. Anyways, let's move on. Ugh, I don't know how we can move on from this. Chris, let's go on from this. Call needs a Snickers. Yeah. Thank you, Chris. I appreciate it. All right. That's my biggest reserve for driving up to Michigan on Tuesday is I can't afford it, guys. Can't afford to do that and then drive to another country on Friday. So I want to, but I can't. And I do appreciate your guys' super chats. I do, but it's a hard ask. It's a hard ask, and I'm trying to figure it out because I want to do it. I wanna email Judge Simpson's court clerk and just say, hey, I will be there on Tuesday because, like, as you guys know, from a week ago or 2 weeks ago when I was there, she emailed me and said, next time you're here, next time you plan to come, let us know so we can talk to you. And I want to respond to that, and I want to go up, and I want to do that, and I want to take her up on that. But life's more important right now, and that's where my head is. I gotta stop before I start crying. Sparkle Poots is probably gonna give me some words of wisdom here. Perhaps you should listen to voices that care. Yeah, Sparkle Poots, thank you, Sparkle Poots. I appreciate it. All right, that's where I'm at. Not saying Tuesday's not gonna happen. Legal fiction, Great White Northland. Yeah. See, here's the thing. Like, I'm so excited. Like, I'm gonna not doing it. Legal fiction. Thank you so much. That's just where my head's at, guys. I care way more about my trip on Friday than I do on Tuesday. But all right, Wixom. All right. I will drive up there. I will drive up there for you. You want to take care of my expenses? I will do it. I will drive up there Tuesday, and yeah. So it's on you. I will be there Tuesday. Tuesday will be Magoo. Wixom said it. So we're gonna do it. I'm gonna go up there, and we're gonna hang out with Wixom. We're gonna hang out with Bob. I will email Miss Wilding on Monday tomorrow and let her know that we're gonna be there, and we're gonna get the prime treatment. So Wixom, be there early on Tuesday. This is on you. You want this? You got it. I got you. I got you. So it's gonna happen. I'll be there on Tuesday. So yeah, let's go. Hold on, Chris, for gas to Canada. Oh, thank you. I didn't say that for super chat, but I do appreciate it. I didn't say that for super chats, but I do appreciate it. And of course, Wixom. See you Tuesday. Thank you, Wixom. I appreciate it. Oh, Wixom, that's stupid generous. All right, Wixom. All right, we're gonna have. Hopefully, I can get a backstage pass with Judge Simpson now. All right, let's go. Empire Lady with the $2. Thank you, Empire Lady. Coming in with $2. Empire Lady, thank you so much. Like that means a lot. That means a lot to me, Empire Lady. Thank you so much. All right, you guys ready? Let's just go. Let's keep rolling.
Next matter is the state of Michigan versus Chelsea Brink. It's filed 25-43824.
Yeah, guys, I'm trying to continue the court cases, but you keep dropping generous super chats. Super sticker. What is that? Sick of what? Sick of fatalization? Sick of italicization. I have no idea, but I do appreciate the super sticker. Very generous of you. Thank you so much. All right, Wixom. Then I don't know why I said Wixom. That's not who I. Let's just go.
SM for a status conference. Do you see Ms. Brink is here? Mr. Brown is here as well. Do we have a resolution of this matter, Mr. Brown?
We do not, Your Honor. This is a trespass case. As far as I know, there hasn't been any offer in the matter. However, I did speak with Ms. Brink, and it that we didn't really get into the facts of the case. She wants to set this matter for a trial.
Is that accurate, Ms. Brink?
Yes, it is, Your Honor.
All right. What we're going to do is we'll have this set for a one-day trial, gentlemen. Is that going to be sufficient?
More than, yeah.
Yes, Judge.
All right. Prior to the trial, we'll need criminal jury instructions as agreed upon by the counsel. If there's something that's not agreed upon, it'll have to be taken up at the hearing at the last final status conference. So one set of criminal jury instructions, exchange, witness and exhibit lists within 30 days. Evidentiary motions filed within 30 days and heard on the day for the final status conference, and a final status conference 1 week in advance to make sure that we're ready to go to proceed to the trial. Ms. Brink, setting a trial means that you're going to need to be in contact with your attorney, because there are a lot of things that he needs to talk to you about prior to the trial. So I'm going to set a status conference just like this 1 week in advance to make sure that everything is ready to go for the trial the following week, which
Nora, I did get it. Nora, thank you so much for your Venmo. I do appreciate it. Thank you so much. Also, Tammy and Sparkapoos. Thank you guys. Thank you guys for your I don't know what to call them. Your PayPals and your Venmos. I guess that's the best way to do it. Thank you guys. You guys are awesome. But yes, I absolutely did get it. Thank you so much. I do appreciate it.
means that I want you to have lots of contact with Mr. Brown before that status conference. Don't wait for the status conference. Don't wait for that final week to try to get ready. Make sure that you're ready to talk to him ahead of time so that he knows all of your concerns and he can talk to you about all of the legal issues that come up with a jury trial. There's lots of moving parts at a jury trial, not only with the jurors, but with the legal issues that come up prior to that. And I want to have as many issues ironed out ahead of time so that you can make a good decision about whether it still makes sense to have a jury trial before we actually have to bring in all of the jurors. I don't want to have them waiting and sitting around while you're trying to decide what to do. Does that make sense?
Yes, sir. Thank you.
All right. Any other questions that you have, Ms. Brink?
So if I'm understanding you correctly, there's going to be 2 court hearings, a status conference 1 week prior to the jury trial, correct?
Correct. And we'll send you out notices of when that is. I don't know when that is right yet because I don't control the docket. I don't have the calendar in front of me. So we're going to mail you a notice of when the jury trial is going to be. And 1 week in advance of that, we'll have a status conference just like this over Zoom. The jury trial will be in person. So you'll have to come to court for the jury trial. The status conference will be via Zoom, just like you're doing today.
Sure. And then, so I'm sorry, hang on, let me write this down real quick.
Yep, go ahead.
For the trial, is that going to be in the district courtroom or the?
Correct. Correct.
Okay. Okay, I think that answers all my questions, Your Honor.
All right. As long as you get a hold of your attorney quickly and stay in good contact with him, we should be good. All right. That's all for
Yes,
today.
sir.
Thank you.
Thank you.
You're welcome. I have 2 files on Jonathan Wenner versus State of Michigan versus Jonathan Wenner, file 25-43901-SM, set for a status conference. And then we also have Jonathan.
All right. Sorry I missed the pause. Yeah, that last lady was the person that everyone's been following. She's a mess, but she's getting her stuff together, which is good. But she has a criminal case now, trespassing, which is what you just saw, which is the only reason I played it. But now we get into this guy. That's all I gotta say. Let's go.
State of Michigan versus Jonathan Wenner, file 25-43924-FY, set for a status review. Is that you, Mr. Wenner, in the jail?
Yes, it is, Your Honor.
All right, thank you, sir. Looks like we have Mr. Brown covering on this case, on both of these cases as well. Mr. Brown, do we have a resolution of either matter?
We do not, Your Honor. I know that Mr. Wenner has been wanting me to go to jail to visit him. I did that yesterday. The conversation did not go very well. I don't believe we had much accomplished. He wants, as far as both these cases, I believe, to have a criminal responsibility examination set, and he would like to request a new attorney.
And a full psychological evaluation, Your Honor.
You can certainly pay for a full psychological evaluation, but I don't believe that there's any law that requires the court to pay for that on your behalf. There are two.
It has to be approved. It has to be approved by the court in order for community mental health to help me set that up.
As far as criminal matters go, I don't know why the court would order a full psychological evaluation. I don't know exactly what you're looking for. There are 2 standard orders that the court enters in criminal cases. One is called competency, and that looks at whether or not you are able to understand the criminal justice process and able to assist your attorney in representing you during that process. That's, do you understand the nature of the charges and the court proceedings? And do you understand enough to be able to assist your attorney through that process? The other court order that could be done is called criminal responsibility. And that's a determination of whether or not you were legally insane at the time that the crime was, that the crime occurred. A psychological evaluation is typically used in family court matters to determine what types of assistance that you may need with mental health in proceeding through another court hearing in family court or in civil court, or in making some assessments about what type of programs or services that you may need. And those are typically not available in a criminal court. So what is it specifically that you are asking for of the court?
I'm requesting a criminal responsibility test and a full psychological evaluation that community mental health told me on Tuesday this week that you guys can order and approve, but it has to be approved through you. Yes, there's a 6-month waiting list, and I do not care about staying in here that long. I need a full psychological evaluation done and community mental health told me that you can approve that to get that done.
Well, then I'm going to need to have something from community mental health that tells me why I need to do that and under what circumstances they're looking for it and what they would use it for. So without something in writing asking for that, I can't know what specifically you're asking for and why I need to order it. Those things are expensive. And if I don't know why I need to have it or why you need to have it, I don't know. I'm not going to just do it out of due course.
Your Honor, these things are absolutely necessary and relevant to my defense because I'm having psychological issues without my medication during the times of these crimes.
I still need something in writing, and that's done in every criminal case. I need something in writing from your attorney and or from community mental health as to understand what the purpose is being used for. I understand that you believe that it's relevant, but I need something in writing from a person with.
It's absolutely relevant to my case.
I understand that you think that, but I don't know that for sure yet. So I need something from community mental health that tells me why, and it needs to be in writing so that the prosecutor and the court can decide on that. And I need more than 30 seconds notice to be able to reach that decision. So I'm going to need something.
I have my attorney come see me before this court date to let you know these things. And I also told Mr. Brown yesterday that I would like the paperwork or to request the paperwork or whatever I need to do to get a new court-appointed attorney because he is not representing me to the way that I need him to.
Just because you disagree with what your attorney tells you doesn't mean that you have the right to have a new attorney.
Your Honor, he's telling me that he won't do things, he won't talk to witnesses, he won't do none of this unless he feels that it is necessary. That's not the way this works.
Unfortunately, it is.
No,
your
it's not,
attorney
Your Honor. I'm sorry.
You don't get to tell your attorney what it is that you want to do all the time if it's not appropriate. He's there to help you understand what is and is not appropriate. There are things that you do.
I've not said nothing to him. I've not said nothing to him that's inappropriate, Your Honor. He's refusing to do things for me.
This is not going to work if you're going to talk over me.
I need a new court-appointed attorney, Your Honor. I'm sorry. Larry Brown is fired.
Unfortunately, you don't have the ability to fire him. You've asked for a court-appointed attorney. The court has appointed him. You can ask.
I'm requesting a new court-appointed attorney because of him not doing his job the way he should by representing me properly.
All right, Mr. Winter, here's how this is going to work then.
I also have past experience, Mr. Brown, by not representing me properly.
Shut him off for a minute.
How many times do you guys want to tell me that? Just shut that guy off for a minute. I had to speak up. Yeah, shut that guy off. Let's go.
He's muted.
Thank you. Mr. Winter, this will not work if you're simply going to talk at me. I need you to understand what I'm going to say next, and then I'll unmute you, and you'll be able to tell me what it is that you want me to know. But this will not work if you're simply going to come into court and try to dictate what is going to happen. Your rights are going to be preserved, but you do not run how the court works. If you want to ask for another court-appointed attorney, I will grant that request. But if the next attorney comes in and does things that you do not like, I will not appoint another attorney for you. You do not get to fire anybody when you ask the court to pay the burden of that attorney. And you're going to be stuck with whatever advice that attorney gives you. Period. End of sentence. Please unmute Mr. Winter.
So I don't have the right to unmute him, but I have requested it if there is an officer in there.
Just for the record, Your Honor, there is a form that he must fill out. If he fills that out, gets that back to me, I will get it to the proper authority for determining whether he's entitled to a new attorney.
Thank you, Mr. Brown. So, Mr. Wenner, you're gonna have to fill out a form to ask for another court-appointed attorney. And I'll approve that once it's gotten to me, and then you'll have another attorney. Do you have any other questions for the court today, sir?
Besides adjourning or postponing or whatever the preliminary hearing in order to do this, no. Or whatever you gotta do for postponing the hearing or whatever you got. Besides that, no.
Your Honor, I guess I misunderstood. Is he wanting the prelim within 21 days, not willing to waive it?
No, I think he's asking to postpone it so that he can get a new attorney. Is that correct, Mr. Wenner?
Yes, but also at that time, I would go through the attorney on whether to waive the 21-day rule or not.
Well, I don't know how long it's gonna take to get this new attorney for you.
And
The arraignment.
yes, Your Honor, I think. I'm sorry, Your Honor, go ahead.
Thank you. The arraignment on file 43901, which is the misdemeanor case, was in July. The arraignment on the felony matter, which is file 43924, was in the beginning of August. So I think we've got some time, and we should be able to get a court-appointed attorney change in that time period before he has to waive. Let me see if there's any other court dates set yet.
His prelim is set for next Thursday on the felony case.
All right. Mr. Winter, right now, the preliminary examination is set for August 21st, which is a week from now. And I doubt very seriously if the attorney is going to get changed and up to speed within that time frame. So do you want to go through that process and bump the preliminary examination back? That is to waive your 21 days to allow that process to occur?
Yes, I would like to waive that 21 days, yes.
All right. I will find that then there's been a proper waiver of the 21-day rule. I'm sorry, go ahead.
I would like to request, there is other charges that I'm being charged with that I don't think that I've been arraigned on. And I'm not sure if you have given me Barry Brown for those charges or not. I would also like to not have him for those charges either.
Let me ask the court staff to advise me how many other charges we have outstanding against you. That's going to take.
I've been arraigned on them, but they're not outstanding.
Judge, there should be 4 cases.
4 cases total. He has 2 scheduled for next Thursday.
All right. We'll use this same process in all your cases, Mr. Winter. And we'll try to set them all at the same time so they're not bounced like this back and forth. So I've got all the files in front of me next time. And we will set this for a status conference in approximately 2 weeks to allow the new attorney to get in and get up to date on you. I'll ask that attorney to come meet with you ahead of time so that you can have a discussion with that attorney about what your concerns are and what you believe should be done in your case. But again, I want to caution you to understand that that attorney is going to make up his own independent mind about what it is that's appropriate and what is not appropriate. And he will tell you when you have the right to make the decision and when he has the right to make a decision, depending on what the case and the circumstances are. And you're going to be required to keep that attorney because I'm not going to let you keep firing attorneys simply because they don't do what you want them to do. You understand?
I do, Your Honor.
All right. So we'll set a status conference on all 4 of your cases in approximately 2 weeks. We'll send that to the jail and then we'll see you back here in 2 weeks, hopefully having discussed all these matters with your new attorney. All right. That's all for today. Thank you.
All right. That's it. That's all I got. I overshared tonight, guys. I am so sorry. I did overshare. You guys are awesome, though. Thank you so much for hanging out with me. But that's it. That's all I got. So you guys know, I am probably going to I'm hopefully going to see Magoo in person on Tuesday. I'm going to be traveling on Friday. But yeah, it's going to be a good week. Either way, it's going to be a good week. We're going to have a great week. And thank you guys all for the super chats, the membership milestones, the gifted memberships, the PayPals, the Venmos. You guys are awesome. Thank you so much. The mods, thank you. I do appreciate the hard work. We are set up to raid Katie Zed. She might be done by the time we get there. She might be done, but we're at least set up to go to her. So hopefully she still has a little bit of show left once we get there. You guys are awesome. I'll see you guys tomorrow night. Tomorrow night's Members Monday. That's it. That's all I got. Until next time, bye. Bye.